Good afternoon, ladies and gentlemen. My name is Rob Shepard, and I am the president of the Quinnipiac University School of Law Federalist Society. On behalf of myself, the Quinnipiac Federalist Society, the Connecticut Lawyers Chapter of the Federalist Society, I would like to welcome you to today's panel debate. I'd like to take a brief moment to thank Brian Freeman, Peter Bowman, and the rest of the Connecticut Lawyers Chapter of the Federalist Society, without whom this event would not be possible. I would also like to thank Attorney Vitkowsky, Professor Dunlap, Captain Sulmasy, and Mr. Milan for the roles in today's event. Before we proceed, I would like to take a brief moment of silence to honor those past and present who have sacrificed so much so we can freely assemble and debate these issues today. Thank you. As indicated on our society's banner, James Madison, the father of the U.S. Constitution, is the Federalist Society's hero and inspiration. Madison once famously noted that knowledge will forever govern ignorance, and a people who mean to be their own governors must arm themselves with the power which knowledge gives. To better understand ourselves as citizens under a representative government, we offer today's debate on whether alleged terrorists should be tried in U.S. courts in hopes it will enlighten us so we can in turn better govern ourselves. In furtherance of this desire to better ourselves as citizens, I ask that each of you show our panel experts the utmost respect, even if you do not entirely agree with their positions. Thank you.
Hi, good afternoon. My name is Doug Malin. I'm the managing editor of the Connecticut Law Tribune. Welcome this afternoon, and thank you for spending part of your day with us here. Today we're discussing the issue of trying alleged terrorists in U.S. court, and I think this day is going to be well worth your time as we have a distinguished panel to talk about the issues involved. To my immediate right is Professor William V. Dunlap, who teaches here at Quinnipiac University School of Law. He is the former chair of the section on international law with the Association of American Law Schools. In the middle, we have attorney Vincent J. Vitkowsky. He's a partner at Edwards, Angell, Palmer & Dodge in New York City. He's the adjunct fellow of the Center for Law and Counterterrorism with the Foundation for the Defense of Democracies. And to my far right, we have Professor Glenn M. Sulmasy. He is the chair of the law faculty at the U.S. Coast Guard Academy. He's a National Security and Human Rights Fellow at the Carr Center for Human Rights Policy at Harvard University. Today's topic is certainly one that's become a hot-button issue recently. The discussion is where and also how to try alleged terrorists in the U.S. It's an issue that involves discussions about using the civilian courts, using military commissions, or, as Professor Sulmasy will discuss, using something else altogether. There also are questions about security that come into play when talking about civilian courts, and as many people know, there have been talks of trials being held in New York. Some have mentioned New Haven. There's also an underused supermax prison in Illinois that has gotten some tension for the process. So without further ado, I would like to introduce our first speaker today, and that is attorney Vincent J. Vitkowsky.
Thank you. Thanks to Rob and Brian for organizing it, with my fellow panelists, and again to all of you for taking time today. Let me set the stage for the discussion by talking about the two alternative systems that we now have in place in very broad terms. We have the civilian criminal trial system. That's available for criminal offenses against anyone, aliens, U.S. citizens, legal residents, anyone. Next, we have military commissions, which were created, and it's important to understand this, created by Congress, and in their current incarnation by this Congress, pursuant to the Military Commissions Act of 2009. They were created following guidance from the U.S. Supreme Court and the Hamdan decision about the procedural elements necessary to pass constitutional muster. And they apply only to aliens. They apply the international law of armed conflict plus also applied to a series of enumerated defenses that are set forth by Congress in the Military Commissions Act. Now, in broad terms, we have two systems in place, and we should use both systems because each one is appropriate for certain circumstances. This this panel is driven largely by the upcoming trial of Khalid Sheikh Mohammed and the 4 other accused 9/11 terrorist plotters. And it's clear as can be that they should be tried by a military commission. And I say that, and I'll go into technical reasons as we go on, but there are 3 broad animating principles that lead me to that conclusion. First is, the question of how to prevent terrorist attacks is more important than the question of precisely where you try people who have already committed them. Next, American values are important, but we need to recognize that there are competing American values, and the protection of American lives is as important as any of them. And third, reality is more important than symbolism, and the argument most often made for civilian trials is symbolism. I happen to think that's an incorrect argument. The symbolism will actually backfire, and I'll explain why. But when you apply those 3 principles, you conclude that trying KSM in a civilian court would be a true man-caused disaster on national security, propaganda, and public safety grounds. And I think it's interesting to note that we're doing it in Connecticut, and the view I've just expressed is shared by such radicals as Joe Lieberman and Richard Blumenthal. Let's start with national security. The trial will give the people who are trying to kill us valuable counterintelligence. They'll learn about our intelligence sources and methods. It'll help them shut down leaking parts of their organization, emphasize other initiatives that we know nothing about. Based on existing Supreme Court cases, it's not clear entirely what rights, what due process and other constitutional rights apply to aliens in different contexts, except one. If you try them in the U.S. in civilian courts, they have the full panoply of Bill of Rights protections. And those protections can hurt our ability to protect intelligence. Here's where it gets just briefly technical, but you need to understand that there's an incoherence among 3 elements of the criminal justice system, and they really can't be reconciled. The first is Brady rights, and Brady rights are the rights. What it means is that the prosecution must disclose evidence in its possession that goes to either guilt or punishment, any exculpatory evidence to the defense. Second feature is the right of self-representation. Terrorists can refuse lawyers and can represent themselves in the civilian courts. The Supreme Court has said it's absolute, although we've been playing with it on the fringes, and I'll talk about that a little later, but it's an absolute right. So you have the right to exculpatory evidence, the right to represent yourself, and the need to protect sensitive information, either classified information or just valuable and sensitive information. Now, the way this is balanced in civilian courts is under something called CIPA, which is the Classified Intelligence Procedures Act. And it doesn't really do it. It was designed for the threat of the Cold War, not for global terrorism. Under CIPA, the presumption is evidence will be revealed and made available to the defense if it's useful to counter the government's case or to bolster the defense, unless there's some compelling reason not to. And the way it typically works is that there's a pre-trial CIPA hearing, closed hearing with the judge, in which defense counsel and the judge hash it out. here's what needs to be disclosed, here's what we can't disclose, and the judge can either order disclosure or order a substitution, which is some kind of a written written summary or variation, redactions. They can decide that they're going to, if you're listening to tapes, for example, that they'll fuzz out portions of the tape. And then the judge will decide what is to be disclosed, and he can require that it be disclosed. And if the government still will not disclose it, there's a full range of sanctions up to and including dismissal of the case. And this is a very serious issue. Folks that I know best in the last administration have many times had to weigh whether to prosecute against the possibility of dismissal, against the possibility of disclosing classified information. Now, the problem with all this is when you have a self-represented defendant, he can never be in that SEPA hearing. He can never be hearing what it is he's not supposed to be hearing. And so the stage is set for objections and challenges as you go ahead. It's also worth mentioning that SEPA only applies to classified information. And there's a lot of information which, although not classified, is very useful to the enemy. I mean, the classic example is that during the trial of the blind sheik for the 1993 World Trade Center prosecution, the prosecution turned over a list of unindicted co-conspirators, a couple hundred names on it. And within 48 hours, that list made its way to bin Laden in Sudan. He could see that, for one thing, his name was on the list. And that's the first time that he knew that we knew who he was. He could also see who else was on the list and discern how we got it, how we found out, and shift operations elsewhere. It is worth noting that that 1993 World Trade Center bombing case is often held up as an example of a successful prosecution. If you did it there, you can do it anywhere. It's worth noting that the judge in that case, Michael Mukasey, and the chief successful prosecutor, Andy McCarthy, are both opposed to civilian trials for KSM. So by using civilian courts, we're giving away a lot of things that we don't need to, and that's why many of the so-called successes in the past are illusory. I just spoke about the first World Trade Center bombing. Another one is the case of Zacarias Moussaoui. He's the so-called 20th hijacker, and again, it's often said that, well, if you could try Moussaoui in a civilian court, why not KSM? In fact, that case was a mess. Moussaoui was indicted in December of 2001. He was sentenced 5 years later. In all, the case went to the Fourth Circuit 3 times. The last decision just came down in January of this year, 9 years later, and Moussaoui pled guilty. I mean, if he had not pled guilty, his trial would still have not taken place. And the status of his representation was a little convoluted. First, he refused court-appointed defense counsel with security clearances, and then he went on to represent himself. He misbehaved, put mildly. He filed, there were repeated outbursts in court, and then he filed pleadings with things like, Leone, you bitch. It was Judge Leone Brinkema was the judge. Leone, you bitch. But ZM must get the wicked tyrant Congress 9/11 report. So not only is it was insulting, also there were a lot of things a lot longer than that he filed that our security people had to spend time looking at and saying, is this code for something? Is he sending messages? What's going on? Ultimately, Judge Brinkema revoked his right to represent himself, and it may or may not have withstood constitutional scrutiny had it gone all the way up the line. But that case really put a focus on the inconsistency of trying to reconcile these things. It's fair to say, and I'm sure Professor Dunlap will say it if I don't, that there are elements of all of these things in the current military commission's system. There are Brady rights, right to exculpatory evidence, there's a right of self-representation, and there are provisions modeled after SEPA, although not quite the same as SEPA, but they're nuanced enough to make it a much less pronounced problem. Under the Military Commissions Act, you can have better ability to close proceedings, to handle classified information, and to handle sensitive national security issues. Now, proponents of civilian trials will say that judges and prosecutors are smart enough to work something out, to make up on a case-by-case basis procedures that'll deal with all of this. And as far as they can tell, critical leaks have not occurred in the past. And the response to that is, do we really want to keep dancing on the edge of disaster when the stakes are this high? The judges are hardworking, brilliant. The prosecutors are as tough as can be. They're not infallible. They can't think of anything. If Professor Dunlap doesn't do the rejoinder to my unindicted co-conspirators comment, let me do it. People will now say, well, yeah, but McCarthy, he didn't ask for protection. He didn't ask for a classified document treatment of that unindicted co-conspirators list. Nobody can think of anything. And also, you can't control what happens in open court in real time. One of my favorite cartoons is from the New Yorker. And it's a shot of a jury, and the jury is just aghast. I mean, their tongues are hanging out. They're hanging over the rails. And the judge says, the jury shall disregard the last remark. So, we shouldn't leave it to judges and prosecutors to make it up as they go along. It's just too dangerous for the rest of us. The next part of the disaster is that holding a civilian trial will give KSM a grand stage to broadcast propaganda which will inspire and embolden the current generation of terrorists and future generations of terrorists. There will be grandstanding, just like there was in Moussaoui. But even putting aside any grandstanding, it's a no-win situation for us symbolically, because for three reasons. One, we'll do what we need to do to convict them, most likely. And that means stretching civilian court provisions, fashioning remedies that might or might not be constitutional, fashioning procedures along those lines. And that can corrupt our system for ordinary criminal defendants. It's, the Irish have a great phrase. They distinguish between terrorists and ordinary decent criminals. Next point is that KSM has already been prejudged by President Obama and Attorney General Holder. Holder said failure is not an option. Well, failure is always an option. And pretty unprecedented, by the way, for the President to pronounce that ahead of time, the Attorney General, that a defendant is guilty. And third, if we lose, we're going to hold them anyway. We're going to hold them indefinitely under the law of armed conflict until the cessation of hostilities, which will never come. And so where's the symbolism in that? How's that going to be played on Al Jazeera after an acquittal? Now, at the trial, the defense will be to put the government on trial. I mean, it always is. And in this case, that means the Bush administration. I don't want to be partisan, but it is a relevant fact that there are elements of the Obama administration that want to hound, punish, attack the Bush administration, the CIA, for policy positions they disagree with. So the trial could be a show trial to appease that base, which will be projected badly in the rest of the world. So symbolically, it's a no-win. The third problem is public safety. The trial will impose enormous additional economic burdens and security risks on whatever community it's held in. The first time I had a debate on this, it was the plan was still to hold it in New York City. More or less simultaneously, Mayor Bloomberg was being visited by all sorts of people. He was told by the real estate trade groups that they would not be able to sell a condominium in Tribeca for the next 5 years. He was told by business people in Chinatown, all the small business people, that they would essentially be put out of business. There are a couple of residential buildings near the courtroom, Chatham Towers. Their residents were being visited by the New York City police with questions like, can we use your balcony for a sniper post? The local board, I think, voted, I don't know, unanimously, 40-0 or something like that, to suggest that it be held on Governor's Island. That didn't really work either. Anyway, New York was a bad idea, New York City. But wherever it's held, New Haven would not be a much better idea. It would not. Wherever it's held, it's going to raise the profile of that community. The community and the vicinity will be a natural target for flashpoint. Motivation will exist for attacks on that. Why? The trial should be held at a remote, secure location, and I think Guantanamo would actually be ideal. Yeah. In another panel on this subject, we had a discussion much like the one you'll hear today, where we were talking procedure and policy and principle and all of those things. And I got a question from the audience. Ordinary woman raises her hand and says, what about the jurors? And that got me thinking that there would be at least 12, or with alternates 18 or 24, more victims of 9/11. The jurors are going to have to give up years of their lives. They will have to, they may or may not learn classified information, probably would. They might themselves, likely, be targets of terrorist reprisals for the rest of their lives. Now, I know the response to that is, well, yeah, but that's kind of also exists whenever there's a mafia trial. The jurors have the same risk, and they manage to get through it. And the mafia has a better domestic infrastructure than Al-Qaeda. And the response to that is, we don't have a choice with the mafia. The only legal system in place to try them are the civilian criminal courts. Here we have a choice, and we should make a wise choice. The tragic part of all of this is that it would be a self-inflicted disaster. We can discuss this more later, but for now I'll say that in their current form, military commissions have been approved by the current Congress and even the current administration for some terrorists. It was really quite a serious exercise in the summer and fall of 2009, leading up to the Military Commissions Act of 2009. The Supreme Court has said that there are some baseline due process rights. Interesting questions as to how they might apply if they were, if proceedings were held in the U.S. or in Guantanamo, and we can debate that. But there are some baseline due process rights, and that if we were modeling it after our system of military justice, there would have to be at least enough of a similarity with the way our court-martials are conducted to have the system survive constitutionally. And there were great pains to do that. And the Defense Department, the Justice Department, and the current administration have said that with the MCAs as now constituted, they have no problems of reciprocity. If a U.S. serviceman were to be tried under the same procedures in another country, they would have no objections. So I'll close by saying that if the Obama administration does not reverse course, something can be done about this, and Congress may do it. There are two ideas percolating. First, there's a bipartisan bill to deny funding for any civilian trials. It has not been attached to anything. It's one of those floating out there that can be attached to anything on short notice. Second approach is a bit more direct, and that's jurisdiction stripping. The district courts are inferior tribunals under the Constitution created by Congress. Congress created them. Congress can define their jurisdiction and could strip them of jurisdiction in a one-sentence act in a way that would not tie our hands with respect to future terrorists. We can discuss that more in the Q&A if it's of interest, and I hope we will. But for now, I'm going to stop, and thank you for your attention.
Thank you, Attorney Vitkowsky. Up next, Professor William Dunlap from Quinnipiac.
I had never heard that, the remark before about the Irish distinguishing between terrorists and ordinary decent criminals. And I have no idea how this distinction cuts, but I would remind you that it's only been a few years since those terrorists were heroes to many people in Ireland, and some of them are in the government right now. So attitudes do change. We have a judicial system that's the envy of the world. It's a model for the developing world and for the former Eastern Bloc countries as they try to embed the concept of the rule of law into their new political systems. We send judges and prosecutors and defense attorneys from state and federal systems and military lawyers around the world to assist and advise in the development of legal systems like ours. And now, while the eyes of the world are on our courts, waiting to see how this country will deal with the people who are suspected of waging a war of terror on the United States and its allies, we're considering removing those cases to court systems that are designed to facilitate convictions and obscure the transparency that has become the hallmark of our criminal courts. International terrorism is not a new thing, and our response to it as a nation has had two prongs all along: the military and criminal law enforcement. For many years, our military prong was fairly subdued in the face of bombings of Marine barracks in Beirut, the Nairobi embassies, the USS Cole, other assaults on US nationals and interests around the globe. But after September 11th, 2001, it wasn't subdued anymore. And we had wide support from the international community as we led a coalition whose goal was to wipe out al-Qaeda in Afghanistan, toppled the Taliban government. But that got sidetracked by the invasion of Iraq, and both of those have become bogged down now. And to the extent that the judicial side, the law enforcement side, was viewed as part and parcel of the military response, it got sidetracked and bogged down too, by the indefinite detentions of detainees at Guantanamo Bay, by coercive interrogation of prisoners held there and at Abu Ghraib and elsewhere, and by the attempt to set up a system of military tribunals that violated constitutional law, United States statutory law, international customary law, and treaties to which the United States was a party. Probably the biggest problem with the tribunals, at least from the perspective of the world community, was that the tribunals appeared to be designed to ensure that terrorist suspects brought before them were convicted or detained, whatever it was the government was trying to achieve. And however we decide to handle these cases going forward, that's a perspective that we need to keep in mind. Our allies, particularly those in Europe, have expressed concern about the treatment of our prisoners. And our allies' willingness to continue cooperating with us may hinge in part on how we deal with these people. Our standing in the eyes of the Muslim world in particular can rise or fall on how they see us treating those who fall into our hands. My position is that while military tribunals have a role under United States law and under the Geneva Conventions and other rules of the law of armed conflict, they do not have a role in trying these international terrorism suspects. And neither should any special court purpose-built to deal with terrorists. The Article 3 courts of the United States, the civilian courts that try defendants accused of violating the criminal laws of the United States, are the appropriate and proper venue to try these international terrorism suspects. And I have basically two separate but related arguments to back this up. One is that the civilian courts, as I will call them, have been doing this job for years and have done it well. There's no reason to take it away from them. And second is, as I've already mentioned, turning the task of trying terror suspects over to another system, such as military tribunals or a proposed national security court, would be a mistake. First, they are not equipped to handle these cases. And second, it would send at least two negative messages to the world: that we do not trust our own criminal justice system, and that we need to create a special judicial system to ensure convictions that we might not be able to obtain in ordinary civilian courts. Let's look at the positive argument first. Criminal courts for terror suspects in federal civilian courts have been working for years and working well. Since 1973, there have been about 150 terrorism-related cases, depending on how you define terror-related and how you count court cases and related cases. But about 150 have been filed in federal criminal court. 1 under the Nixon administration, 2 under Reagan, 9 under Clinton, and more than 120 under President George W. Bush. And a few more have been filed since President Obama took office. The federal courts seem to have handled these cases quite effectively, but critics have voiced a variety of concerns, and we've heard some of them this morning or this afternoon, in an effort to take these cases elsewhere, to the tribunals or to a national security court. One of the concerns has been that federal prosecutors do not have the legal tools that they need to prosecute these sophisticated, elusive, shadowy terrorists. That the U.S. criminal laws are not sufficient to allow effective prosecution. And as Vincent mentioned, these same arguments were made in terms of the mafia as well. But when it came time to try these very difficult mafia cases, Congress came up with laws that allowed the prosecution. And even if the laws that allowed the prosecution of the mafia, which often apply very well to international terrorists, don't work in these cases, Congress, our political branch, our elected branch, a branch that operates openly, can pass new laws and provide the tools that the prosecutors need. Although most of the prosecutors whom I've read about or whom I've talked to think that we have the tools now. Existing criminal statutes cover virtually the entire range of criminal activity that international terrorists engage in. We have the ordinary criminal laws: homicide, assault, destruction of property, aircraft piracy, money laundering, racketeering, arms dealing, and, probably most importantly, conspiracy and attempt to do those things. In addition to these ordinary laws, there's a broad range of statutes specifically designed to deal with terrorists. Probably the most important are the material support statutes, to prosecute people who provide material support to designated terrorist organizations or material support in furtherance of a terrorist act. There have been some complaints about the constitutionality of these, and some adjustments have been made, but as a general rule, these laws are available to federal prosecutors. They can prosecute people for receiving military training from a designated terrorist organization, prosecute people for providing and collecting funds to be used in an act of terrorism. Chapter 113B of the Federal Criminal Code provides a number of terrorist-related charges, and of course there are treason and seditious conspiracy statutes as well. And while it's not always easy to prove the elements of these crimes, there are other crimes unrelated to their terrorist activities that prosecutors frequently use as well. Immigration violations, identity theft, credit card fraud, financial fraud, fraudulently obtaining travel documents, making false statements to federal investigators. These are all crimes that terrorists or suspected terrorists have been detained on, and in some cases have been prosecuted for when it becomes difficult to prove the specific terror charges. And although the prison sentences for these incidental offenses may be relatively light compared with terrorism charges, after several years in prison, followed by deportation, the defendant is typically unable to reconnect with the terrorist organization that got him started on that route in the first place, often because the relatively short sentence makes their former comrades think they may have been cooperating with the United States government. And in some cases, they have been cooperating. Conspiracy charges, which have been used with organized crime very effectively, have been instrumental in persuading low-level participants to inform on or testify against higher-ups in the organization. The conspiracy statute and rules of evidence allow into these trials a broad range of evidence that could be difficult to introduce in a trial strictly on the underlying substantive offenses. And the Pinkerton rule allows participants in a conspiracy to be convicted of substantive offenses arising out of the conspiracy, even if the defendant did not directly participate in the offenses. Leverage of this sort, the conspiracy, the Pinkerton rule, have gained the cooperation of defendants in a number of cases because they were facing very long prison sentences. But if lack of appropriate offenses with which to charge the terror suspects is a problem, how is transferring these prosecutions to another system going to remedy this? If the plan is to try them for violating laws that do not yet exist, then those laws could easily be tried in federal court as well as in military commissions or a national security court. Classified information, as you mentioned, is another problem. The civilian courts have been fairly effective in that regard. They do not simply turn over every piece of evidence that a defendant requests. The Supreme Court has made clear that the government has a legitimate interest, this is a quote, the government has a legitimate interest in protecting sources and methods of intelligence gathering, and we expect that the district court will use its discretion to accommodate this interest to the greatest extent possible. These and the other remaining questions are within the expertise and competence of the district court to address in the first instance. That's the United States court speaking in the Boumediene case. In 1980, well before combating international terrorism was a major priority in this country at least, Congress enacted the Classified Information Procedures Act with its comprehensive procedural framework for handling sensitive information in federal criminal cases. And according to a study by two former federal prosecutors and published by Human Rights Watch, no international terrorism case since September 11, 2001 has been dismissed on grounds related to classified information, and there have been no important security breaches in cases in which CIPA has been invoked. There is the case involving Sheikh Rahman and the list of unindicted co-conspirators that got leaked to Osama bin Laden, in which he saw his name on the list. He saw his name on the list at least 2 or 3 years after he had already declared war on the United States. And I don't think we can just lightly dismiss the fact that the prosecutors could have invoked CIPA and could have tried to classify that information if they had thought it was important at the time. And soapboxes. Some people are worried that trials in civilian courts, which are constitutionally open to the public, will become soapboxes, opportunities for terrorist defendants to create the kind of spectacle that Slobodan Milosevic put on at The Hague or that Zacarias Moussaoui put on during his trial. The International Criminal Court for the former Yugoslavia was still relatively new at that time, and the judges were still unsure of how to handle an awkward situation. But federal judges are not particularly noted for tolerating the use of their courtrooms as political theater. Judge Brinkema, as you mentioned, revoked Zacarias Moussaoui's pro se status because of his outbursts and eventually sentenced him to die with a whimper, as she put it at his sentencing. It was a military judge at Guantanamo who invited 5 9/11 defendants to speak before the media and the victims' families in an effort to gain their cooperation. Several years ago, I attended a symposium at Fordham Law School in which a panel of a half-dozen federal judges discussed terrorism cases over which they had presided. To me, one of the most telling remarks was from Judge Shira Schindlin. When they invited me to speak, my first thought was, why me? I've never had a terrorism case. She was there because she had presided over the Adewale case, in which the defendant had been held as a material witness, charged with making a false statement to a grand jury about not knowing 2 of the 9/11 hijackers, and after 5 years in confinement and 2 criminal trials, was acquitted by a jury in New York. The government treated it as a terrorism case, which from their point of view it was, but Judge Schindlin saw it as a federal criminal case, which of course it was, and there appears to be no evidence today that the acquittal of Mr. Adewale was wrong. He apparently was innocent of the charges that had been brought against him. Federal courts and prosecutors and investigators have proved themselves entirely capable of handling these cases. And if the fear is that civilian courts will not be tough enough on terror suspects, the evidence shows that sentences in civilian courts tend to be longer, and convictions tend to be more predictable than those from military commissions. But just as the civilian courts have extensive experience in these cases, the military tribunals have relatively little, and the National Security Court doesn't even exist yet. The Defense Department has been trying to recruit civilian lawyers with experience in terrorism cases because the defense lawyers don't have sufficient experience. It could take years to get the tribunals or a national security court up to speed and to get their prosecutors and judges comfortable with what the civilian courts do as a matter of course. But that may be just a minor quibble. My major concern is with the whole concept of creating a court system to deal with a particular class of defendants. How are the American public or the world community or the defendants themselves going to regard a judicial process as fair when its very reason for being is that we were afraid the defendants might be acquitted by the civilian courts? If the Geneva Conventions and the law of armed conflict protect these prisoners, the military tribunals and probably the National Security Court violate their rights to have their status adjudicated by a regularly constituted tribunal. And if LOAC, the law of armed conflict, does not protect the defendants, the tribunals or special court may well violate their equal protection rights under international human rights law. A tribunal or a court established only for aliens poses more than just a public relations problem. The United States would certainly not be the first to try something like this. The United Kingdom got around just a couple of years ago to disbanding the diploc courts, the special tribunals that they created especially for the Irish Republican Army suspects seized during the Troubles that started again in the 1960s. And the Republic of Ireland still has its special criminal court used to try terrorism suspects and now organized crime defendants as well. This creeping jurisdiction, extending special institutions or procedures to new situations when they work well, or loosening constitutional protections when they become inconvenient and seem to get in the way, is one of the great fears when dealing with special courts. And the problem of world opinion is not a fantasy. The diploc courts and special rules on detention and interrogation that the British invoked during the Troubles gave Britain a bad name and are not known to have been particularly successful in preventing terrorism. The Special Criminal Court still has a bad reputation in many circles in Ireland. It's almost inevitable that tribunals or courts of this sort are going to be denounced around the world. And I don't mean by everybody, but I do mean by people who have an interest in what's going on in these cases, that they'll be denounced around the world as star chamber proceedings, as kangaroo courts. I hope that's not a politically incorrect insult to kangaroos, but what? I've already heard the proposed National Security Court compared with the Volksgerichtshof, the People's Court that Hitler established for national security cases after the regular criminal courts acquitted some communists charged with starting the Reichstag fire, a fire which Hitler himself was probably responsible for. This is the court that sends Sophie and Hans Scholl and the rest of the White Rose to be guillotined. The comparison is ludicrous. I mean, I have no interest in making the comparison. But the point is, special courts do not tend to have good reputations, and this, I think, will hurt the image of the United States. I don't mean to sound alarmist, but I do think that the creation of special courts of this sort pose a threat to the integrity of the American judicial system. If their purpose is to loosen evidentiary standards and reduce procedural safeguards, that will almost certainly increase the likelihood of convictions. But that's not a good thing if we wind up convicting innocent defendants. We have evidentiary rules and safeguards in procedure for a reason. American prisoners already hold a shockingly large number of innocent prisoners. And these are people who were convicted under the strict rules of the criminal justice system and our full panoply of constitutional protections. What's likely to happen if we loosen those rules for the express purpose of gaining more convictions? That surely would undermine the integrity of the system. Let me close by quoting Judge Kuhnauer, who presided over the 2001 trial of Ahmed Ressam, the so-called Millennium Bomber. Such objections, he says, often begin with a false premise that the threat of terrorism is too great to risk an unsuccessful prosecution by adhering to procedural and evidentiary rules that could constrain prosecutors' abilities. This assumes that convictions are the yardstick by which success is measured. Courts guarantee an independent process, not an outcome. Any tribunal purporting to do otherwise is not a court.
Up next, Professor Glenn Sulmasy from the U.S. Coast Guard Academy.
Thank you very much, Doug, and thanks to the Federalist Society and Brian and Peggy and friends of mine from the Society and Rob from the student chapter, as well as Quinnipiac Law School for having us here today. It's great to be here. I will say up front that my two good friends sitting to my right managed to insult me. I am an Irishman and have a family that was persecuted by the Nazis, so thank you very much. It's a good way to start off our day and keep us going. It is great to be here with two good friends whom I've been and known for at least a decade in many ways to discuss such vital issues in America today. In many ways, when we talk about Guantanamo, where we are now, it really defines who we were as a country, who we are today, and the America we want to be in the 21st century. Before I begin, I think it's important. The Federalist Society really does a great job, and I want to highlight that for those that have not been a part of it. It does give you the opportunity to sit and have these debates with people of different perspectives, which is the important idea, I think, and what the Federalist Society pushes. And it's fun to be here today because it's always great. In 1995, when I was a law student down in Washington, and one Judge Bork was speaking. And in 1995, there were approximately 6 tables for the annual banquet in Washington, kind of the culmination of the 3 days in Washington, D.C. And there were 6 tables of 10 people for a total of 60 people for his address to the Federalist Society group gathered in Washington, the National Convention. And last year, I believe the number was 1,600 attending the annual banquet, which is pretty impressive by any measure. And I think most people have enjoyed seeing it grow, and I hope the Quinnipiac chapter continues to grow because it does foster intellectual debate. I also want to say, just 45 minutes down the road, I am from the Coast Guard Academy, one of the nation's 4 military academies. There are 4 in the country, West Point, Annapolis, Air Force, and just 45 minutes down the road in New London is one of your nation's military academies. And I encourage you all to come, to visit, to come and tour our museum, to see the parades every Friday afternoon, bring your families, come to the football games. It's not UConn basketball, women's basketball, but we have basketball games, and I have 2 of our cadets here today representing America's finest, and it's an honor to teach there every day, and I do encourage you to come anytime and to call me if you want a tour of the facilities. In that vein, I am in my individual capacity today, in an academic capacity, and any government employees or former government employees know you have to say you're here speaking in your private capacity. Anything I say does not necessarily imply endorsement by the U.S. government. So civilian courts, military courts, we're talking about this again. 8 years ago, I had the exact same debates. 8 years, we're still mired in the debates of the past. 8 years, whether we use military commissions or whether we use civilian courts. 8 years, still doing the same thing. And perhaps most importantly, Khalid Sheikh Mohammed that Vince mentioned is really the best, or perhaps the most recent example, but the best example of the confusion and the complexities and ambiguity associated with the legal regime when we deal with the al-Qaeda fighters. When Attorney General Holder discussed Khalid Sheikh Mohammed, he said, we want to send him to civilian courts, and that was fine. We thought that was great. But his justification for sending 5 others that same day, KSM et al., there were 5, and there were 5 to 8 others going to military commissions. So we had KSM, the mastermind of 9/11, going to civilian court. At the same time, we had 5 to 8 of those that were attacking the USS Cole in 2000, prior to 9/11, going to military commissions formed after 9/11. And I think that highlights for me in many ways because, strangely, KSM not only did, God forbid, he did attack the World Trade Center and hit New York, and my family was there, and it's terrible, but he also hit legitimate military targets like the Pentagon. And the fourth plane, thanks be to God, it did not hit, but it was going to hit the White House or the Congress, legitimate military targets. You would think that that would be a proper place for him to go, but it exacerbates or shows the tension between where to put these people and often the intellectual inconsistencies with how both administrations have proceeded. So in many ways, I say it's time, 8 years later, to move the debate forward. No more partisanship, no more name-calling, no calling those that support military commissions war criminals or looking to prosecute them, no looking for those who embrace civilian courts like Bill and say somehow he's tacitly supporting al-Qaeda, somehow he's embracing al-Qaeda ideology. The reality is that both sides are patriots, looking in an earnest way for the best way to proceed with something that is relatively new. It is since 2001 that international terrorism has taken to the stage to act like a nation state, to have the force of a nation state, and declare war on the United States and the West. Really, what we need now is Congress, and some are, Senator Graham and others, are looking and working with Rahm Emanuel. Policymakers in Congress need to embrace a third way, no longer remaining trapped in these debates of the past, no longer remaining in partisanship and bickering, but move forward and embrace a third way, a hybrid of the two systems, a hybrid of the military commissions and the civilian courts. And that's really why I wrote the book, The National Security Court System, that Bill has. What I intended to do is to offer a pragmatic and bipartisan solution. Thank you very much. Shameless, aren't I? Is to offer a bipartisan, pragmatic solution to this. Rather than staying, fighting, engaging in the policies of the past, the president, new Congress, let's look forward and move forward and put this debate to rest. Because as I said, when you listen to Vince, my good friend, and you listen to Bill, my other good friend, they're both right. But at the same time, when you listen closer, they're both wrong. Neither system fits neatly for the al-Qaeda fighter that we're trying to detain, interrogate, and hopefully adjudicate. Neither one is fitting neatly, and that's why we're having to split and have a bifurcated system. We need one system to best accomplish this task. So when you say, okay, Glenn, why are they right, why are they wrong? Military commissions. Vince eloquently spoke to it. Bill eloquently spoke in civilian courts. Why not military commissions? With all due truthfulness, I did support military commissions. When I was at the Heritage Foundation, I wrote in favor of military commissions, anticipating they were going to begin in 2003. It's 8 years later. 3 trials have taken place, and one of them was a plea bargain. But if we look at it, I think military commissions are lawful, and I would suggest both administrations do. President Obama clearly does, as well as does President Bush. The reality is that they are part of our history. They are part of statute embodied in the Uniform Code of Military Justice. It has an article providing for a military commission distinct from courts martial. We have precedent, the Kieran case and other cases that have been used, and I can talk about that in Q&A if we have time. And also in the customary laws of war. These have been going on since 1648, the idea of prosecuting the few who violate the laws of war in a special court designated for those who violate the laws of war. King Adolphus of Sweden, 1648. In American jurisprudence, the reality is that we have the first military commission was conducted with General George Washington over the great West Point caper, with Benedict Arnold's co-conspirator, if you will, Major John Andre. It's been used in General Jackson's time, President Jackson's time. They've been part of our history. President Lincoln conducted 4,000 military commissions during the Civil War. We know in World War II there were at least 2 cases in the European theater and several more in the Japanese theater. The interesting part, it's part of our history. It's provided by our precedent. Our Supreme Court precedent has supported these. It's part of the customary laws of war. And when I say about a precedent, I do want to detail for a second, because it is interesting to think. When President Bush made the decision to go with military commissions, I suggest he did think it was the right thing. He wasn't trying to set up some special tribunal or create a backroom deal. I think he truly thought it was going to be rapid like I did, because the Kieran case that he relied on and the order that he promulgated on November 13th was virtually the same as President Roosevelt's of 1942 for the Kieran 8 saboteurs. From the point of their capture to their habeas hearing before the Supreme Court special hearing during the summer to their military commission, conviction, and execution of the 6 of the 8, it was 42 days. I think the administration thought this is the way it would move forward, but the reality was things had changed, and 2 distinctions had taken place. One is that the military commissions were intended to be used for the minority who violate the laws of war, the few. Roosevelt's commission was for 8 specific individuals, distinct from President Bush's order that said everyone associated with al-Qaeda will now go to a military commission. Interestingly, right, at the height of Guantanamo, 775 were held in Guantanamo Bay. Secondarily, the other miscalculation was that military justice had liberalized since 1942. The Uniform Code of Military Justice was written in 1950. We didn't even have judges at all in 1942 for the commissions. It was just line officers would do it. JAGs wouldn't even be involved most of the time. So you have that sort of a distinction. So I think as a matter of law, the military commissions are fine. Glenn's perspective, as a matter of policy, they have not worked. They're never intended for all people associated with al-Qaeda. They were intended for the minority, the few. Secondarily, perceptions do matter, and the reality is that the fighter we're fighting wears civilian garb when we're trying these. The artist renderings of Guantanamo Bay show a civilian, an otherwise civilian, although he's a fighter of some sort, a warrior of some sort, but wearing his traditional garb. And you see military officers who normally are quite intimidating. I am not, and I think the cadets would tell you I'm probably not to them in the classroom either, but normal military officers are. They've got their ribbons, their material, they've got their uniforms on, sitting before the rest of the world sees a civilian being tried in the United States or on an island off the United States by military officers. Rightly or wrongly, this is an international fight, we need our partners with us. And they see that and they say, what is America doing? America's gone off course. That's what we usually condemn people for in Latin and South America for similar type of activities, military trials of civilians, even though they are some sort of war. So it never fit neatly. So as a matter of law, I think the military commissions are fine. As a matter of policy, they never were intended for this, and we've misapplied them, and they won't work. As a matter of for civilian courts, again, Bill spoke eloquently to it. The reason our great halls of justice, why not embrace, Glenn, our hallmarks of the world of military justice? We are the centerpiece for justice in the world, the United States courts. Those of you that are in law school are going into a great profession in America. It's a noble profession. So why not, Glenn? Why not embrace the civilian courts? I think similarly, it's not fitting neatly. It's not adjusting to the threat. Judges, even in the habeas proceedings, 37 of the 50 trials after Boumediene before a civilian district court, a federal district court in Washington, D.C., 37 of the 50 have been found to be released. They should be released. I think that's dangerous. I think our judges, federal judges, if there aren't any in the room, I think are wonderful. They're tremendous judges, but they're generalists. We already have special judges for immigration, for tax, for bankruptcy. For something as important as this, why would we not have a bar or judges, federal judges that are appointed, created, that are experts in this area? And I've been on panels with judges who are calling just for this. Chief Judge Rosen in Michigan, who's where the Abdul Muttalib, the Christmas Day bomber, is going to be tried, is calling for some sort of a person that would perhaps do the habeas proceedings, a special judge who is more specifically dedicated to this niche area of the law. Because you have international law, sure. Underneath that, you have the law of armed conflict. You have intelligence law, human rights law, humanitarian. This is a niche area. This isn't what a generalist would necessarily be comfortable with. So there are judges asking for it. And so I think our judges are wonderful, but not necessarily the right fit. As Vince alluded to earlier, juries, I think, it's kind of counterintuitive to our hallmark of justice to say we're going to impanel an impartial jury when the commander-in-chief says we're going to convict everyone. Or they're going to have their day in justice. They're going to have justice. We have to be conscious of what we're saying. If we're going to provide justice, let's do it the right way. But it's so difficult. How could we possibly impanel an impartial jury for Khalid Sheikh Mohammed? Let's be realistic. The intention is there, the right thinking is there, but reality has to confront us. It's not going to happen. Constitutional rights. We're talking about, everyone will say, Miranda and Fourth Amendment and Fifth Amendment. Those things are common for us in law school and studying law and as lawyers. But gosh, military soldiers fighting overseas have never had to think about that. And some of you say, well, Glenn, they don't have to. It's an alien outside the United States. It's not going to happen. It's happening right now, and pleadings are going. Any good defense counsel, once Boumediene opened the door to a constitutional right for the al-Qaeda fighters, is going to seek Fourth and Fifth Amendment. In fact, Neil Katyal, now the Deputy Solicitor General for the Obama administration, in his Hamdan pleadings right after Boumediene, had a list, laundry list. They were rejected by the military judge, but sought Fourth Amendment and Fifth Amendment protections. So what we really need, when we think about it, we have these two systems that aren't fitting neatly. So if we look at it, we have to kind of embrace what we're dealing with, a hybrid fighter in a hybrid war. The al-Qaeda fighter is really a mixture of a warrior and an international criminal. That's what's creating this ambiguity. International criminal and a warrior. The war itself, we're using more law enforcement than ever before. We're using the FBI and the CIA more than ever before in the United States history, overseas with our armed forces. So it seems logical to me, if we have a hybrid fighter in a hybrid war, it's logical that we create a hybrid court system. Because right now, I think the key is to do what? Is to make that difficult balance between national security, which was spoken about, but also our long-standing commitment to the promotion of human rights, which all of us hold dear. As of now, we have forum shopping. We have the military commissions, possibly. We have the civilian courts, possibly for some. We have indefinite detention for 50 or more, holding people without charge or trial for the duration of hostilities. In this war, guess what? The war is generational. There's not going to be a signing. There's not going to be a treaty signing on the USS Independence in the Persian Gulf to say, oh, the war with al-Qaeda is over, and Osama bin Laden will sign a declaration to give up. It's not going to happen that way. It's a generational war. We have to be conscious there is no end. Beyond that, we also have Bagram looming in the distance. You may have seen in articles recently gurgling, calling Bagram President Obama's Guantanamo. That's gurgling with 800 people. More than we had at Guantanamo Bay right now is over in Bagram, Afghanistan. And interestingly, when we're talking about process and rights and how that should go forth, I think we have to, while the Christmas Day bomber was being captured, and read his Miranda rights, he trained in Yemen, we know that. His co-conspirators or fellow al-Qaeda members were being fired at, who are fighting in Afghanistan or in Pakistan, by unmanned predator drones and being killed. There's no process for those people overseas. We have to have some sort of intellectual consistency of how we're going to engage in this armed conflict we are in. So my concern is to create these national security courts. But in doing so, what both spoke about, I think the key is to still preserve both of our systems. We don't want to disrupt military commissions for the future. In legitimate, traditional armed conflict, I want to still be able to use them, as do most military commanders and commanders-in-chief. We don't want to erode them to the point where they're no longer useful to be rapid justice. That's what separate military justice system is for. Similarly, I don't want to erode our civilian courts. We don't want to have our systems being degraded or decreasing expectations of privacy for a Fourth Amendment issue because someone raided a safe house to get a computer over in Yemen and bring it over and decrease expectations. We don't want to have the next crisis in civilian courts to have people lower those standards for the drug war, per se, near and dear to the Coast Guard's heart. We don't want to have that. So the real key is balance and pragmatism. And the National Security Court that I propose is run by the Department of Justice rather than DOD, is to have civilian oversight. Have habeas hearings within 3 months of capture by judges that are dedicated to national security law. And there are enough professors, academics, and practitioners in the country to sit on such courts or be appointed, or have existing federal judges serve terms for 3 years in that capacity, perhaps in conjunction with FISA. Trial within 1 year of every single al-Qaeda fighter. Trial in a national security court. No juries, just 3-panel judges, but a trial within 1 year of capture. So the system that I propose, different from others, is presumptively adjudicatory. So we're balancing all needs, presumptively adjudicatory. On military bases, inside or outside of the United States. Presumptively open proceedings, and perhaps what's come up often is the idea of a sunset provision, which I think is important. Bill talks about the diploc courts. I would also say that, gosh, one of the great things about our country is if it's not working, we can end it. Just like with the Patriot Act, if we choose to reissue it, we can do that. If the war on al-Qaeda does cease to exist and we don't want to have abuse, sunset any provision for such a court to be in existence so it reduces the opportunity for abuse. And also, I would just mention last, one of the items that Congress needs to look at, and Congress needs to do this with the President, is to look at France. Yes, they're a civil law system, but guess what? France has had tremendous success with its ability to combat terrorism. In fact, in 1985, very similar and eerily similar, there was a plot, a conspiracy to attack the Eiffel Tower with airplanes, 2 to 3 airplanes to hit the Eiffel Tower to destroy it in 1985. They discovered it, disrupted it, and still they've been relatively safe since their time of their new system. We should explore other systems, find the weaknesses and the good side from our international partners. So I suggest to some, the hybrid system or a national security court system will achieve that best balance of our need for national security while still upholding that long-standing commitment to the promotion of human rights. The President of the United States right now doesn't need any more bickering or partisanship, nor do any of you. We need solutions. Congress needs to sit, hold hearings, and actively pursue other options to remove the ambiguity in the legal regime. The National Security Court system, the National Security Court system is something that needs to be considered right now. Thank you very much.
Gentlemen, thank you very much. We're going to open it up for a couple minutes here and just have some discussion among panel members. I first wanted to give the other panelists an opportunity to address any point that another speaker made that you weren't able to address in your own presentation, if there's one.
I'll try to do it really, really quickly. Bill referred to the Human Rights First report on civilian trials, and I commend that report. It's excellent, well-written, and balanced. It has some good quotes in it, for my purposes. It says that CIPA is not foolproof, that security breaches may occur. CIPA does not address the proper outcome when a defendant attempts to represent himself pro se. It does not address the potential expansion of the scope of classified information that may be sought by a defendant who's facing the death penalty. Interestingly enough, I did a debate on this with one of the authors of the Human Rights First report. And he began his remarks by saying that there were really 2 questions. 1, can civilian courts try terrorists? And 2, is it a good idea to use a civilian court for KSM? He went on to say he was there to make the first point. Civilian courts can do it. But he was not taking a policy position on the second point.
I just have a quick one. I think Bill raises a good point. I do take issue with the idea that somehow military commissions or national security courts are means to ensure conviction, to ensure convictions. I think it's tough to say. I think all of us, it's hard, this is where it becomes difficult. All of us want to see these people convicted. It's hard to remove ourselves from the emotions, including the President and the Commander-in-Chief and the Attorney General, who have said they wanted convictions in civilian courts. So I don't think it really matters necessarily whether it's a military court, a national security court, or a civilian court. The reality is that all of us would like to see them convicted, and having, I think that's kind of a red herring to raise that these are just for conviction purposes. The reality is that I would suggest that everybody wants to see, even in civilian courts, similar sort of outcome.
Well, that's true. I did not mean to suggest that the only rationale for the tribunals or the National Security Court was to ensure a conviction. And in fact, they won't ensure convictions even there. So if I overstated that, I apologize. Looking at that from a different angle, you mentioned the problem of finding an impartial jury for Khalid Sheikh Mohammed. I think it's certainly going to be impossible to find a jury who doesn't know about this case and who hasn't read a lot about it. But that's the same problem that the courts face in Connecticut with the murders in Cheshire. Everybody knows about it, and what the courts need and what the Constitution requires is not a jury that doesn't know anything about it. We don't need ignorant jurors. We just need jurors who are willing to listen to the evidence at trial and hand down a verdict based on the evidence they hear. And I think there are ways of screening out people who would simply be unwilling to give the Sheikh or any other defendant in these situations a fair trial.
Before we go to a Q&A, I just want to toss out a couple of questions to the panelists. For Glenn and Vincent, I guess under the ideas you proposed, To what degree do you lend credence to the thought that foreign countries won't help America in terms of extraditing alleged terrorists, in terms of just being on our side when it comes to trying alleged terrorists?
World opinion is an interesting concept. First of all, let's talk about the 1.17 billion people in India who are themselves the subject of attack by al-Qaeda. I don't think they're going to be reluctant. Talk about the 1.2 billion Chinese. Well, of course, they're laughing at us for even bothering to hold trials. Throughout Europe, there is a bit of a problem, but it's a reverse problem. Let me say, and as for the Muslim world, moral suasion doesn't work with people who behead their captives and then broadcast it on the internet. There is a problem with the moderate Muslim world, and I think Bill raises a good point in the message that we send to people who might or might not be inclined towards terrorism. Oh, the problem comes up when a court requires a disclosure of classified information that was obtained through a foreign intelligence agency. Let's assume that we got it through somebody in Europe. Let's assume that the defendant is a citizen of that country, the Netherlands or something. Let's assume that we're seeking the death penalty, which Europe doesn't acknowledge. There will be times when the governments will not share information. First of all, if the court orders it that we ask the government, we can ask, and then there's a foreign relations mess. And there'll be other times when the information might not even be put forth as a result of fear of this kind of disclosure.
Thanks for the question. I think it's critically important. I'm of the belief that this is an international armed conflict. We need our international partner support in order to move forward. I think one of the problems with Guantanamo as a matter of policy is that it's been tarnished to such a degree. That's why the military commissions won't necessarily work, because they have been tarnished to such a degree that our international partners will never render any verdict there, whether guilty or not guilty, or even a plea bargain as not having been improperly gained. And I think that's one of the items when I was talking about the misapplication of the commissions normally used in traditional armed conflict, as in Germany in the Kieran case. It's against one nation. We're fighting Germany and Japan, but against citizens of that nation. We're at war, a declared war. In this case, what's unique, we have citizens of Great Britain, of our allies, citizens of Australia, our own citizens, citizens from France, all participating in al-Qaeda, and how we try them becomes even more complicated. So I think it's critical in the national security court system to ensure, and I think it would be, with civilian courts, civilian judges in robes, the hybrid system being on military bases with a mix of federal U.S. attorneys and also federal public defenders, civilians trying the cases with JAG support, that you have a much more the right message being sent to our international partners around the world, and that's the right way to do it.
Bill, you have any ideas where a civilian trial should take place? I mean, we were talking about the on-the-ground chaos that could or that would follow an open trial, talking about the impact on local neighborhoods.
It makes no difference to me. I don't own any property in Tribeca, so I'm neutral on that question. But yeah, I don't think it's necessary. In fact, I was a little surprised, even when it started to become clear that they were going to try Khalid Sheikh Mohammed in criminal court. I was a little surprised when they chose downtown Manhattan as the venue. There probably were better choices just from a practical point of view. But my guess is that the criticism would have come flying from a different direction if they had chosen to try him somewhere else. That the complaint would have been, well, the people of New York have a right to have that trial here to see what happens. The attacks took place here, we should have the trial here. I think this is one of those situations where whatever the government decided to do, there was going to be just enormous criticism.
And let's take the next 10 minutes or so to open it up to the audience if anyone has a question. I'm not sure if we have a microphone in play. We do have a microphone. So if people could just line up here if someone has a question, or if you can speak loudly enough and just pose your question, that'd be fine. We can take a few minutes to do that.
question that I always find difficult is who's a terrorist? Especially if you're not talking about someone who's found on a battlefield. And how do you make that distinction? And how do you keep this from sort of expanding into anyone who we're scared of, right, as it did in Ireland?
I'll take that. Thank you for the question. One of the items that I'd like to say when we do discuss these issues, it can't be done in a vacuum. I think it's improper for us to say we close Guantanamo and just do civilian courts or military courts. We need a broader look for the question that you raise. One of the items that I propose along with this, and I've written it in U.S. News World Report just after the Obama election, was to change the name of the war officially. One of the items you have to be able to do is not say the war on terror, but make it more finite, change it to the war on al-Qaeda, call it what it is so we at least have some idea who the terrorist is. That might be too narrow, but we've got to take it and narrow it from its broad perspective as of now. And I think it's important to note that Neil Catchell, who did represent Hamdan, and Jack Goldsmith and Stuart Taylor and myself all support the national security court system for citizen and non-citizen alike. I had gone back and forth on that, but I think that the important item is that we don't make the confusion of having U.S. citizens who are engaging the same activities as someone over in Yemen doing, suddenly having more constitutional protections than would someone overseas when they're doing the same thing on the same telephone call. That would create ire from the international community.
I have a question primarily for the gentleman from the Coast Guard. I forgot your name, I'm sorry. You said you were concerned by the number of habeas cases that were granted. It seems to me that courts, district courts, hear habeas court cases as a matter of common procedure. It's nothing unusual, and in fact, they'd be very qualified for habeas cases. It's something that happens all the time. Sure. I'm not sure why that gives you such cause for concern. I find the idea of Article 2 courts that you're suggesting rather a great deal of concern for me because they may upset the apple cart of balance of powers. It gives me a sense of national insecurity, actually. And in times of war, it seems to me that, as Justice Jackson said in Woods, that when the war powers are being used to do something to the liberties of the people, that we should scrutinize the constitutional basis with care. And I wonder if you have anything to say about the balance of powers issue here.
Sure. No, I think first, your question about habeas, it's an important one. We all hold habeas dear to our hearts as lawyers and citizens. What the misconception can be is that we're at war. We are at war. The president has said that and the former president has said that. And a POW during times of traditional armed conflict and in accordance with the Geneva Conventions doesn't get a habeas hearing. We've provided the opportunity in this unique circumstance just to those at Guantanamo to provide them a habeas proceeding. That's what happened. Partly because we felt, as Justice Souter noted in the Boumediene decision, which I'm certain you've read, he noted that he was concerned about 8 years of people not being held without charge, that we should at least provide that. So having said that, being held by military, captured by military, brought into a military base, being detained by military persons, what my suggestion is, and I think many folks in Congress are starting to think this way, is that we need to have that learned judge. I'd be much more comfortable, I'd be much more insecure, as you note, having people that don't understand intelligence law, don't understand military law, don't understand human rights law, don't understand international law, and are not experts in it. And we should have judges that are actually of that mindset to conduct these very, 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 very important proceedings, especially with a 20% recidivism rate, which we all know now, which is pretty popular knowledge, of those that are being released. Thank you.
What role do you think the history of the Bush administration not recognizing Geneva protections and the Geneva Convention plays in this? And when I say that, if we had, do you think we'd still be having this debate if immediately when we pulled these people off the battlefield, we immediately said, well, though they weren't signatories to the Geneva Conventions, we're going to treat them as if they were and give them those protections? I'll pose that to anybody on the panel.
I certainly could take, one of the items would be is that a prisoner of war is held till the cessation of hostilities. So your question would be is if we said Geneva does apply, if we made the decision that the Bush administration made a decision that Geneva Conventions don't apply, what happens if he said and the administration decided they would? The reality is they would all be being held indefinitely. And there would be no opportunity for trial, there'd be no habeas proceeding. If it's held within the customary laws of war, they would be held indefinitely and without trial and until the cessation of hostilities is what the Third Geneva Convention requires. And so we would be in a situation, I think we'd have problems still as well.
You know, it was a close call, even at the Supreme Court. And I'd like to address it more broadly. One of the failures of the last administration was to do any kind of public education or public diplomacy with respect to the articulation, need, basis for its policies. And which accounts for some of the great surprise now that the smart people in the Obama administration have done the same analysis and come out with the same conclusions, and you don't hear you don't have the outcry. So, the Bush administration let itself get outplayed in the construction of the public narrative.
Yeah, the Geneva Convention's question is, I think, a really complicated one that we couldn't go into in much detail here. But even if the Geneva Conventions were to apply, it's not immediately clear which rules of the Geneva Convention apply. For a while, our war in Afghanistan was probably an international armed conflict within the meaning of Common Article 2, so that the full protections would apply. But many of the people we picked up were not members of the military of any party to that conflict, and it didn't remain an international conflict for very long. So I agree, it would still be an issue, but I have no idea what the issue would be.
Well said. Concur.
I guess my question is mostly for Professor Dunlap. Sir, my question is really about attorney bias in civilian courts. At the end of the day, I guess I feel as though people that have committed such indisputably egregious and deplorable crimes against our nation and humanity can't possibly be represented impartially. I understand it is a prosecutor's job to set aside personal opinion, but when your dad was a New York firefighter or your neighbor worked in the Trade Center, how could you not have a strong opinion about it? And the difference between this and the Chester case, in my point of view, is that September 11th undoubtedly personally impacted either you or someone you know, and it's not like you just read about this in the newspaper. So don't you think at least a civilian venue would be more subject to emotion than a military commission?
Well, I think a lot of people in the military also had friends, relatives, neighbors caught up in the disasters that we're talking about here. And I doubt that the people in the military are any less prone to emotion or bias than people working in civilian courts. But remember, one of the questions that needs to be answered here is, are these people guilty in the first place? The fact that somebody is angry about a situation doesn't necessarily mean that the person who's brought into trial is guilty of causing that situation. And that's where we hope that judges and jurors, whether they're civilian or military, will be able to set aside their feelings and actually look at the facts and ask, is this person guilty or not? There's no point being angry at a person who's not guilty.
I guess my question really would be then, how do you propose finding someone that would be adequate in representing a person who, you know, like you said before, we'd like to find convictions for these people, then how do you feel as though we find somebody who can adequately represent a person like that?
Well, a friend of mine who teaches here part-time at the law school is representing one of the defendants in the Cheshire murder case, where two people broke into a house and tortured and killed the three women who lived there. I don't think he has any sympathy at all for that particular defendant, and I personally am pretty certain that the defendant did what he's accused of doing. But the lawyer's job is to make sure that the rights are provided, that he gets a fair trial, that everything he's entitled to under the Constitution and the laws of Connecticut are provided. I don't think lawyers have to like their clients.
That's not really what I'm saying, but I
Oh,
appreciate
I'm sorry, maybe I misunderstood.
But you have to like your
question.
professors. So.
All right, well, thank you, sir. I appreciate
No, if I misunderstood your question or am answering the wrong question, go ahead.
Thank you.
Where they're going to come from, though, is the pro bono bar. 24, something like 24 out of the largest 40 firms in the country have provided pro bono defense counsel to terrorist suspects. Between those, the professors who are involved in the intellectual questions, and the professional, the folks like Josh Stradel, the professional terrorist bar, they're out there. There will be competent defense counsel. And all of those people can show up in a military tribunal as well.
Just had a quick question for Attorney Vitkowsky. Sir, you seem pretty intent on having a military commission take place in Guantanamo Bay, and you mentioned that civilian courts, due to the spectacle, will empower al-Qaeda and international terrorists. And I was just wondering, given the example of American exceptionalism that having Guantanamo Bay has set with our world allies that everyone seems to agree need our support, I was wondering how you would propose legitimizing a military commission in Guantanamo Bay.
By making the case that we have that it's legitimate under first of all, the international law of armed conflict and our and the Military Commissions Act. You cannot completely discount the point that you've made, and I don't discount it. I put it into the mix of things and think everything else outweighs it.
Thanks, sir.
We have time for one more question, and thank you.
There's been some mention today of trying mafia in civilian court and in front of a jury. And I know the recent case of John Jr. Gotti in New York in December went through its 4th mistrial in 5 years. And Professor Dunlap, do you feel that that was pretty much the result of the government not being able to demonstrate that the defendant was truly guilty, or do you think there was a possibility that on all of those juries there was at least one member who feared for his or her life or the lives of a family member and therefore was just unable to come to a decision of guilt?
Actually, I have absolutely no idea. I mean, I read in the paper about the hung juries, but I just don't know anything about the trial or what prosecutors may have thought the problem was in not getting a conviction.
And I have the second hand, I'm going to change the country and venue, but try to address your question. I have the second hand because I was not involved in the troubles of Northern Ireland. But you mentioned the Diplock courts. They were created, I'm told, because you could not impanel a jury. Half the community would have quit, and the other half was afraid to serve.
I want to thank everybody for coming out this afternoon, and thanks to the panelists and all your participation. Thank you.